If you are on an H-1B, hoping to get one, or you are an employer that depends on H-1B talent, a new proposal out of the U.S. House is getting a lot of attention right now. It is being described as a bill that would end the H-1B program by 2027 by cutting the annual cap to zero. That sounds simple, but the real question is what it actually changes today, who could be impacted first, and how you should plan without overreacting. By the end of this video, you will have 3 takeaways. 1. What this bill is proposing in plain English, and what it does not do yet. 2. Which groups are most exposed versus which groups are likely insulated. And 3. A practical checklist you can use right now for status, travel, hiring, and paperwork so you are not caught off guard. Here is the part most people miss. A bill being introduced is not the same thing as a law, but it can still change behavior immediately, including hiring plans, case timing strategy, and even how people choose travel dates. So let us separate facts from speculation and build a calm plan. What changed is a fresh legislative push in the House of Representatives. Congressman Greg Steube introduced a proposal called the Ending Exploitative Imported Labor Exemptions Act, also referred to as the EXILE Act. The key idea, as reported in your brief, is to amend the Immigration and Nationality Act to reduce the annual H-1B cap to zero starting in fiscal year 2027. In other words, it is not describing an immediate shutdown tomorrow. It is describing a future year policy change. No new cap-subject H-1B numbers would be available starting FY 2027 if the bill became law in that form. The brief also notes this is the second legislative attempt this year to end the H-1B route, which matters because repeated attempts can keep the issue alive, even if nothing passes right away. Now, let us define terms quickly because this is where confusion starts. When people say the H-1B program, they are usually talking about the annual cap system, 65,000 regular cap plus 20,000 for advanced degrees from U.S. institutions, often summarized as 85,000. That is the number mentioned in the brief. But not every H-1B is counted against that cap. There are also cap-exempt H-1Bs, like certain jobs at universities, non-profit research organizations, and some affiliated entities. Those cases can be filed without going through the annual cap season. Why does that matter? Because a bill that targets the cap could hit some employers and workers harder than others, depending on how it is written and how it is implemented. This is the first myth versus reality moment. Myth: a new bill means your current H-1B is canceled, or you will be out of status soon. Reality: a bill is just a proposal until it passes both chambers of Congress and is signed. Even then, the exact effective dates, transition rules, and guidance would matter. Nothing in an introduction alone automatically cancels existing approvals. But here is the second part of reality. Markets and employers do not wait. If companies believe the pathway is at risk, they may accelerate filings, adjust recruiting, shift roles overseas, or push harder on alternative visas. That is why you are hearing anxiety right now. So who is affected most, at least in terms of exposure if something like this gained traction? Let us do clear buckets. Bucket 1. People who are not yet on H-1B and need a cap number in a future year. That includes many F1 students planning OPT to H-1B, workers abroad trying to enter through cap subject petitions, and employers that rely on the annual cap season for hiring pipelines. If the cap truly went to zero in FY 2027, the biggest immediate planning impact would be for people whose timeline expects multiple chances at selection between now and then. Bucket 2. Current cap subject H-1B holders and their employers. Even if your current approval remains valid, the system around you could change. Fewer new hires, fewer transfers into cap subject employers if cap numbers are eliminated, and potentially a more complicated environment for long-term planning. But it is crucial not to assume what transition rules would be without actual text and guidance. Bucket 3. Dependent family members, like H-4 spouses and kids, because their status is tied to the principal H-1B. Any disruption to the principal pathway can create downstream stress. School planning, work authorization planning, and travel planning. Now, who is likely not affected? or at least not affected in the same way, based on how H-1B usually works. One group is cap-exempt employers and workers, depending on the specific language. If a proposal eliminates the program entirely, cap-exempt might also be impacted. But the brief emphasizes reducing the annual cap to 0, which sounds like a direct hit to cap subject numbers. You would want to see whether the bill targets only the cap or the broader classification. Another group is people already on entirely different employment categories, like L1 intra-company transfers, O1 extraordinary ability, TN for certain Canadian and Mexican professionals, E2 treaty investors, or permanent residence pathways. Those categories have their own eligibility rules and risks, but they are not the H-1B cap. Again, not legal advice, but the point is, not everyone is trapped in one route. Here is a key edge case that causes a lot of confusion: H-1B portability. Many people believe that if the cap goes away in a future year, it might affect job changes for people who already counted. Under current structures, someone who has been counted against the cap is generally not counted again for a new cap number when changing employers. But that is under current law and policy. A major statutory change could rewrite assumptions. So, rather than guess, the practical move is to understand your personal status timeline and keep evidence that you were counted, approved, and maintain status, because documentation becomes more important when the policy environment gets noisy. Now let us talk about why this is happening, because understanding the drivers helps you predict what could come next. These proposals usually sit at the intersection of labor market politics, wage concerns, enforcement optics, and frustrations with how the U.S. fills high-skill roles. Supporters of elimination often argue the program can be used to undercut wages or displace domestic workers, even though many industries say they cannot fill key roles without global talent. Opponents often argue that cutting off H-1B would harm innovation and competitiveness and push jobs and research overseas. And then there is the operational reality. The U.S. immigration system is a pipeline of constraints. When one pathway gets tighter, demand surges into others. O1, L1, TN, and especially employment-based green cards. That can produce backlogs, delays, and more scrutiny across the board. Here is another part most people miss. In immigration, the announcement effect is real. Even if nothing passes, if enough employers believe it might, they may file earlier, recruit differently, and place bets on alternative locations. That can change the job market for workers on the ground. The brief also mentions an additional layer of uncertainty for aviation, aerospace, and advanced engineering due to changes to the H-1B selection process. It states that the traditional random lottery has been replaced with a wage-based weighted system. I want to be very careful here. Selection processes and USCIS rules are complex and can change through regulation and policy, and not every viral claim about selection methods is accurate in all details. So treat that as reported in your brief, and always verify with USCIS announcements and official program guidance. But the underlying point is valid. If selection criteria become more wage-weighted, employers may need to adjust job leveling, wage offers, and role design, and workers may see different odds depending on how their roles are classified. That leads to a practical planning lesson. Your job title and duties, wage level, and documentation consistency matter more in a competitive selection environment. Now, real-world consequences. Let us make this concrete with the types of issues people face. First, hiring and recruiting. If a company depends on cap-subject H-1B for early career technical roles, any credible threat to the program can freeze offers or shift them to other countries. For workers, that can mean fewer sponsorship opportunities, earlier decision deadlines, and more pressure to accept certain roles quickly. Second, extensions and long-term status planning. Most H-1B holders plan years ahead, including when to start a green card process, when to move to a new employer, and when a spouse might be able to work. Even without immediate legal change, the perception of risk can make employers more cautious about starting expensive processes, or it can make them rush, which sometimes leads to avoidable mistakes. Third, travel. When policy is in flux, Travel becomes higher stakes because re-entry depends on valid documents and the officer being satisfied you remain eligible. This does not mean do not travel. It means plan travel like a risk-managed project. Confirm your documents, check processing times, and avoid travel during critical filing windows. Fourth, families and life decisions. Housing leases, school choices, and caregiving plans all tie into status timelines. The biggest harm from immigration rumors is people making irreversible choices too early, quitting jobs, abandoning a degree plan, or leaving the US unnecessarily. So the goal is to stay grounded. What is true now? What could change later? And what is your best low-risk move today? Let us do 2 example scenarios to make this practical. Example Scenario 1. An F1 student in a STEM program graduates in 2026 and plans to use OPT and then try the H-1B cap. If a proposal says cap goes to 0 starting FY 2027, that student will be asking, does that remove my chance? The honest answer is, we do not know, because the bill is not law. The timeline could change, and there might be transition rules. But what should the student do now? Work backward from dates. Understand your OPT start and end, whether you qualify for STEM OPT extension, and how many cap seasons you can realistically attempt before any potential FY 2027 change. Then align with an employer early, because last-minute sponsorship is where people lose time. Example Scenario 2. A mid-career engineer on H-1B working for a cap-subject employer is considering a job change in 2026. Their worry is, if the pathway is threatened, will my new employer sponsor me? Again, nothing has changed legally just because a bill is introduced. But in the real world, employers may become more cautious. The practical move here is to keep a clean, complete immigration file. Approval notices, I-94 records, pay stubs, job description consistency, and degree evaluations if needed. That way, if you do move, you reduce the risk of delays or requests for evidence, which is often what actually derails timelines. Now let us move into the most important section. What to do now, in a do this and avoid this format. This is general planning information, not legal advice. Do this. Track your dates. Know your current status end date, passport validity, I-94 expiration, and any upcoming filing windows. Many problems happen because people track only one date. Do this. Build a document folder. Keep your last several pay stubs, your most recent W-2, your offer letter, your job description, your degree documents, and past approval notices. If you have a prior employer, keep separation documents too. Do this. If you are an employer, audit role documentation. Make sure job duties match the wage level and the specialty occupation narrative, and keep recruitment and wage determination records organized. Do this. Monitor official sources. Watch Congress for bill movement, but also monitor USCIS and the Department of Labor for rulemaking, forms, and processing updates. Avoid this. Do not treat social media posts as confirmation. A headline like H-1B ending can be designed to trigger panic. Until there is enacted law or official agency guidance, treat it as a planning signal, not a final verdict. Avoid this. Do not make irreversible decisions based on a single proposal. Do not quit a job, leave the US, or abandon a program solely because you heard a bill was introduced. Avoid this. Do not ignore your current compliance. If you are on H-1B, keep doing the basics right. Get paid properly. Keep the job duties aligned. Report material changes through the proper process, and maintain a clean paper trail. One more do this. Consider alternative pathways early, but carefully. For some people, that could mean exploring whether they qualify for a cap-exempt position, whether they have eligibility for O1, whether an L1 makes sense for multinational companies, or whether a long-term green card process should start sooner. Do not self-diagnose from a checklist online. Use official guidance and, if needed, a qualified attorney to map options. Now let us do another myth versus reality, because this one spreads fast. Myth. If the cap goes to 0 in 2027, all H-1Bs end in 2027. Reality. A cap change affects new numbers. What happens to existing status would depend on the final law, effective date language, and transition rules. Many laws have grandfathering or phase-in details. Until you see that, do not assume the worst-case interpretation. Another myth. If my employer is in a high-skill industry like aerospace, the government will make an exception. Reality. Exceptions, if any, would have to be in the law or subsequent policy. It is not something you can rely on for planning. Plan using what is written, not what you hope will appear later. Now, what could happen next? There are a few watch points that matter. Watch point 1 is legislative traction. A bill can be introduced and go nowhere, or it can pick up co-sponsors, get a hearing, or be folded into a broader package. The moment to pay attention is not just introduction, but movement, committee action, markup, and companion bills in the Senate. Watch point 2 is agency guidance and enforcement trends. Even without legislation, agencies can adjust how they scrutinize cases, how they interpret wage levels, and how they handle compliance. Watch point 3 is demand surges. If workers and employers fear future limits, you may see a rush of filings earlier than usual, which can slow processing and increase the risk of paperwork errors. Watch point 4 is litigation and politics. Major changes often face court challenges, especially if implemented through regulation rather than statute. That can create a confusing period where rules change, pause, and change again. The best defense is staying current with official updates and maintaining a flexible plan. Here is a practical plan for different groups in one sentence each. If you are an F1 student, map your OPT and STEM OPT timeline now and talk early with employers about sponsorship timing. If you are an H-1B worker, keep your immigration file clean, track dates, and do not delay long-term planning if you intend to pursue a green card. If you are an employer, diversify your talent strategy, check compliance basics, and do not wait until the last minute to file or to correct role documentation. If you are a family member on H-4, understand your dependency on the principal timeline and plan travel and renewals with extra buffer. Now a quick lightning round of what we can verify versus what we cannot confirm from the brief alone. We can verify the concept. A House member introduced a bill described as the EXILE Act, and it proposes cutting the H-1B cap to 0 starting FY 2027. We can also say it is a proposal and not law at this stage. What we cannot confirm from this brief alone are the full text details, whether it touches cap-exempt categories, what transition rules exist, and whether any other provisions change enforcement or definitions. And regarding the wage-based weighted selection change, treat it as reported and verify against USCIS official communications because selection mechanics are frequently misunderstood and sometimes evolve through incremental policy changes. Now let us wrap this up calmly. Here are the 5 things to remember. 1. A new bill targeting the H-1B cap is a serious signal, but it is not an immediate change to your status by itself. 2. The biggest exposure is for people and employers relying on future cap seasons, especially those building multi-year plans. 3. Cap-exempt pathways and other visa categories may be affected differently, and you should not assume one headline fits everyone. 4. The safest move right now is practical readiness. Track dates, organize documents, and monitor official updates rather than reacting to rumors. 5. Watch what happens next in Congress and in agency guidance, because movement and implementation details matter more than the headline. If you want, comment with your situation in general terms like F1 to H-1B, current H-1B, employer, or H-4, and what year you are planning around. I will use that to make a follow-up video that breaks down timelines and safest planning moves group by group. And if this kind of calm, step-by-step immigration news coverage is helpful, subscribe and turn on notifications so you do not miss the next update.